Good morning and welcome to the First District Court of Appeals. We have two cases on our docket scheduled to be argued this morning, and we will be reordering them. The first case on the docket is C-240430, and I understand there may be an attorney who is late to this case this morning. If you are present in the courtroom, please stand, identify yourself if you are representing a party, and state your readiness to proceed. This case is Zhang versus Zhang. Are the attorneys here?
Good morning, Your Honor. Nathaniel Truitt on behalf of Appellee Veronica Zhang. I believe as of now I'm the only counsel present.
All right, thank you very much. And the second case on the docket this morning is C-240571 and 572, Porter versus Hammond North Condominium Association, and I understand the attorneys are here. Could you please state your name and the party you represent?
Good morning, Your Honor. Nicole Lundrigan. I'm here with Kelly Lundrigan on behalf of the appellant unit owners.
Good morning, Judge. I'm Ian Mitchell. I'm here on behalf of the appellees.
Thank you, and thank you for your flexibility with the docket this morning. We will proceed with the case Porter versus Hammond North Condominium Association, and Ms. Lundrigan, if you would like to come forward, you may. Would you like to reserve time for rebuttal?
I'd like to reserve 3 minutes, Your Honor.
All right, you may proceed when you are ready.
Thank you. May it please the court, I'm Nicole Lundrigan. I'm here with my partner Kelly Lundrigan on behalf of the appellant unit owners, many of whom are in the courtroom today and others of whom are watching. The homeowners we represent in this case have suffered unimaginable tragedy and devastation. They are elderly, many are sick, many are disabled, and they've been forced from their homes by the association and the former board under threat of contempt by the trial court with their decision. Ms. Moore, one of the appellants we represent, she's a single mom. This was her first home that she purchased for her and her son. And she's been out of her home since the fire that happened in February of 2023.
Counsel, what is the current status? Have the residents been moved for the repairs at this time?
My understanding is at least our clients in this case, there are many homeowners that are not part of our case, they have been forced to move out of their homes and they are not residing there at this time. My understanding is that the interiors of their units have been gutted and demolished, but now the association has run out of money. And so they are in a state of unlivable disrepair at this point.
So the construction has stopped?
The construction has stopped as of just a few weeks ago because they have run out of money.
Okay.
So these condominiums have been demolished and gutted, cabinets removed, people displaced out of their homes, and the construction has now stopped.
And I understand that there may have been some changes in the composition of the board. Can you address that specifically as to potential mootness of this appeal?
Yes, Your Honor. My understanding is that a new board was elected, I believe, as of the end of February. And I believe that the board members are new except for one continuing board member. This appeal is not moot, though, Your Honor, if I may address that question specifically, for a number of reasons. First of which is that although some of the injunctive relief may not be able to be obtained, but some of it may. And with the change in the board and the stopping of the construction, there are many issues that have to be addressed, further discovery to be had, but there may be some injunctive relief that can still be obtained in the trial court. For example, an order requiring that the governing documents be followed, that a vote be had on any new plan for how to deal with this mess. Second, the trial court, although it purported to only hold a trial on the injunctive relief portion of our claims, it dismissed count 2 in its entirety. So count 2 was a claim for breach of the governing documents and breach of fiduciary duties by the board members. And the trial court dismissed that claim in its entirety, including the damage claim. So the judge effectively decided the whole case, including the damage portion of the claims, by dismissing that count.
So, counsel, I really want to hone in on the exact status as to the mootness piece. It sounds like, at least as to the counterclaim injunction, that has been fully mooted because the residents have left. Would you agree with that?
I believe so, Your Honor, although they do have a claim for attorney's fees, so that issue is still live. And so we obviously, the appeal's not moot because my clients don't want to be held responsible for attorney's fees or, any other kind of responsibility for delay, which they have claimed in the.
And then with respect to the injunction claim that was denied by your clients, it's your position that there's some declaratory relief underlying that injunction claim that could still be granted and would be meaningful.
Absolutely. And the case law is clear that when there are questions of fact, like there were in this case, even for a declaratory judgment claim, that has to go to a jury. And in addition to the declaratory judgment claim and the interpretation of the governing documents, which really underlie all the claims in this case, injunctive and damage claims, I do think there's portions of the injunctive relief that could still be implemented by a trial court on remand. As you indicated, we have a new board. Construction has stopped. They've run out of money. But we have a number of contracts, for example, with contractors that we allege in the trial court were not properly authorized. So there's, $30 million of money that's been spent that may be able to be recouped. There's some additional money that may be able to be recovered from the insurance company. There's a $55 million policy. And this new board may need to look at other plans to deal with this building. And so there may be injunctive relief that can still be obtained in the trial court in terms of a new plan for how to proceed with this reconstruction potentially once we get back down. And that would, in our opinion, require votes from unit holders on how to proceed.
And is it your position that there are still remaining damages claims that your clients have raised that penned in the trial court?
Absolutely. Absolutely. They have suffered millions of dollars of damages. At the point that we filed this claim in May of 2024, the damage had occurred primarily on the lower levels of the condominium property, including the common elements, and nothing had been done for 15 months. People were trying to sell their condominiums and could not because nobody would buy. The lower levels were just completely destroyed, and nothing had been done for 15 months. So they had suffered significant damages at the point we filed suit in terms of loss of value of their homes. Ms. Moore had been out of her home for 15 months by that point. And by the way, when they're out of their homes, they're paying for a second home rent, but they were still required to pay HOA fees to the condominium association for units they couldn't live in, mortgages. So they're paying for 2 households. And Ms. Moore, when she couldn't afford to do that anymore, the association filed a foreclosure action against her. It's just unconscionable.
So one of the arguments that if I understand correctly, your clients made was there was insurance proceeds that were to go to fixing the units that were damaged, I guess in the downstairs, that were destroyed, and that the association instead wanted to use the money, they wanted to use the money for that, but then they wanted to also add in like the sprinkler system, and that was part of what you all were trying to stop, right?
That's correct, Your Honor. So sections 12.1 and 12.2 of the governing documents are really, really clear about what has to happen with the insurance proceeds when there's been a casualty event. There's no discretion at all, unless the unit owners approve otherwise. So those sections require, it uses the word shall in both sections. The insurance proceeds shall be used to repair or restore the fire damaged portions of the property back to their original plans and specifications unless the unit owners approve otherwise. And during the trial of this case, the board admitted they were using those insurance proceeds other than for repair of the fire damaged portions of the property. They were actually using it for this new sprinkler system, which their own accountant admitted was a capital improvement, which under section 10.1 required the vote of unit owners before it could proceed. And they ignored all of those provisions.
Has that been installed, that sprinkler system?
I believe it's at least partially installed, but I'm not sure the state of installation since construction has now stopped, Your Honor.
Okay.
And I know one of your claims as well was the use of the insurance proceeds.
Correct.
And your position is that the condominium documents require those insurance proceeds to be used to repair damaged units rather than what I'll term upgrades.
Correct.
Have those insurance proceeds been fully expended at this point? Or I know you're saying the association is out of money, or is there any insurance money left to spend?
Yeah, and I don't know the full extent of that, Your Honor. My understanding, the last information I had was that about $30 million of the $55 million policy had been paid out, but that the insurance company was refusing to pay additional funds. And perhaps the parties are in negotiations. I'm not really sure the state of that. But in essence, my understanding is at this point, the association has no more money to proceed with construction.
You've asked us to order a jury trial.
Yes.
If we were to send this case back for a jury trial before the trial court considered the injunctive claims, what would that look like at this point? What would be tried, and what would your injunctive claims be?
I think that the entirety of this case needs to be reversed and remanded. And I think the entire case, all the facts, all the damage claims, have to go before the jury first. And then once the jury determines the facts, then I think that the trial court could decide if there's any injunctive relief that could be had. Because in this case, this wasn't the trial court severed this case on the injunctive relief claims and did that by stating that he was only going to decide legal issues. But that's not what happened, first of all, and it couldn't happen in this case because there had to be factual determinations made to even determine which provisions of the governing documents were triggered. So, for example, the trial court made a finding that there was an imminent risk of harm. Well, that was a highly disputed fact at trial. The trial court should not have ever made that determination. That was for the jury. And that was one of the centerpieces of the reason for the trial court's decision. And we think that was completely improper. So I think the whole case has to be reversed and remanded and sent back down.
So do you envision this, the jury would fill out interrogatories on the specific facts that you believe need to be found, and then the trial court would then use those facts later for the injunctive piece of things?
I think that's the only way it could happen, Your Honor. I think the jury would have to make determinations of fact. We'd have to, they'd have to make the determination of whether damages should be awarded. And then based on those facts and interrogatories, the judge would then have to determine if there's any injunctive relief that should be issued.
Okay.
I think I've addressed most of my argument by answering your questions. Are there any other questions that I can answer for the panel?
I was just going to ask you, and, we're looking at whether the jury trial right is based in the common law, right? And you all, I think both sides have characterized this as a breach of contract claim. But we're really, I guess it doesn't matter, but we're really dealing with a real covenant issue here, aren't we? This is not precisely a breach of contract issue.
So it's interesting. In the First District Court of Appeals in the BEM case, talks about the governing documents of a condominium association. It is a contract, but it also creates fiduciary obligations on the part of the board. And so when the board fails to follow the governing documents, it's a breach of contract and is also a breach of fiduciary duty.
Okay.
Anything else? Thank you very much.
Thank you. Mr. Mitchell.
Good morning, Presiding Judge Kinsley, Judges Bach, Judge Kraus. My name is Ian Mitchell. I'm with the firm of Reminger, and I currently represent the appellees in this case. I'll address a couple of items that counsel mentioned in her opening, and first of all, the human issues and the issues of displacement and the possibility of mootness here, Judge. I believe you brought that issue up, Judge Kinsley, and so I want to mention that first. With respect to the equitable issues that were decided by Judge Nestor in the trial court below, they were very specific to the threshold determinations of whether or not the construction plan should go forward or whether, as the appellants contended, it should be halted. That required necessarily an interpretation of the governing documents, whether or not there was authorization for the reconstruction plan to move forward under the declaration and bylaws, as well as Ohio law, or whether, as appellants contended, it was barred by the governing documents.
Mr. Mitchell, Looking at the entry, the trial court's entry, I mean, it does certainly appear that the trial judge interpreted the documents, but also, it also appears that the trial court engaged in some finding of fact. Like, for example, the board proved the conditions of the entire building are an imminent risk of harm to the owners, third parties, and public safety. Is that a factual finding?
It is a factual finding, Judge, but under Ohio law, trial judges are permitted to make preliminary factual findings to reach a legal conclusion, particularly in the particular phase of a trial where only equitable relief is being considered. So there is some language in the briefing from appellants that essentially says these two issues cannot be dealt with separately. They must be dealt with at the same time. And in fact, equitable issues must be dealt with after all other factual issues and issues related to damages have been determined. But that's inconsistent with Ohio law. Preliminary findings of facts can be made by a trial court judge in order to reach the determination necessary to interpret a governing document or a declaration of the bylaws.
So I'm going to go back to what you just said a second ago with the sequence of what the trial court has to determine. It sounded like you said that the factual findings have to be determined first?
That's what the appellants are arguing.
Oh, I see. Okay.
Which, again, from our perspective, from the appellee's perspective, that is backwards. Under the traditional model, you would have issues related to injunctive relief because of its tendency to cause irreparable harm, because of its exigent nature. You would deal with those up front in the case. And in fact, I think we see that in this case, right? In the docket that was in front of the trial court, the appellants, the plaintiffs in the case below, actually filed for a motion for temporary restraining order. They wanted that relief right out of the gate within the first 14 days.
Are you saying would be a jury trial, the judge would make preliminary findings of fact, and then there would be a jury trial after, where the jury would make findings of fact?
I appreciate the opportunity to clarify. So what I'm suggesting is that when dealing specifically with the issue of equitable relief and whether an injunction is warranted, which is an inherently legal issue for the, it's an issue exclusively for the trial court to consider, they can make preliminary findings of fact on that equitable issue before reaching their decision. And in the same regards, when interpreting a legal document, which is, again, solely a legal distinction that the judge can make, they can make preliminary findings of fact to the extent that they're necessary, right?
Okay.
So on issues like irreparable
But
harm.
when you have a combination of claims, and you have a claim that would go to a jury, then what happens?
Well, so it's a great question, Judge Krause, and I want to also highlight the fact that the claims that were raised in the initial complaint and request for a declaratory judgment and an injunction by the appellants in the case below were primarily claims for breach of contract, but there was also emotional distress claims and other causes of action that were not necessarily intertwined with the request for an injunction, right? And because of the exigent nature of the injunctive relief that was being sought, both by the appellants, but admittedly by my clients as well, the board, there was a reconstruction plan that needed to take place. The building was in a deteriorated state. The city of Cincinnati had come in and indicated that the soot contamination throughout the building was toxic to its residents. A subsequent determination through an inspection was made that there was asbestos in the building. The insurance companies all indicated that they would no longer insure the building unless the sprinkler system was installed. So there was a significant amount of work that went into these inspections and in consultation with experts to determine the exact type of plan that was necessary. So the association, and through its board members, went through an elaborate process in order to try to determine several different things. What the city was going to require to occur to the building in order for it to be considered safe for its residents. What insurance companies would require of that construction plan in order for the building to be insurable on a going forward basis.
Counsel, we understand that there was some factual engagement, let's call it, with the trial court to resolve the injunctive claims
Yes, Judge.
with regard to this set of facts. What preclusive effect does the judicial fact-finding have on any subsequent jury trial on claims that rely on these same facts?
It's a good question, Judge, and I think that gets to the nexus of some of the case law arguments that is in the briefing, right? So we've got the Precision Strip case, the Precision Strip versus Dirksen case. We've also got two cases that have been cited by the appellants, the Beacon case and the Raskow case, and this gets to that issue, right? So specifically, what can be parsed out in terms of its preclusive effect, right? So if res judicata takes effect, the suggestion would be that potentially there is a deprivation of a substantive right, whether it's a jury trial right that could be determined. Here, though, we've got just a determination of the same threshold issues that both parties sought to put in front of the judge from the outset, right? So they don't necessarily get into those other substantive claims that have been raised by the appellants in the case below. This is specifically dealing with whether or not the reconstruction plan for the building could move forward. And certainly findings of facts were made with respect to what the condition of the building was. If nothing happens, is the building going to fall apart such that some sort of injunctive relief at this stage would be essential? Those determinations were made, but with respect...
And that appears to be in dispute. I mean, for purposes of our brief time at oral argument today, let's put a simplistic gloss on it.
Right.
The association, at least at that time, appeared to believe that the building was in need of significant repairs, and that was a negotiation with the city to avoid some code problems.
Correct, Judge.
And the residents appeared to believe something entirely different, and that repair of their units was not necessary, and that they were essentially being compelled out of their houses for reasons unnecessary to them. And that is a dispute of fact, and the trial court resolved that fact in a factual dispute in a certain way. Let's say that the jury reached an entirely different conclusion and sided with the residents as opposed to the association. What then?
Well, so I suppose I disagree to a certain extent with the premise of your question. So it was not all residents who disagreed with the association's action. In fact, there is a large contingent of the residents who had already moved out.
The plaintiffs.
No, residents of the building, not necessarily the plaintiffs. Plaintiffs are a small group who were potentially going to be replaced, but there was an even larger contingent of residents who had already been displaced, who were waiting for the construction plan to be finished, that the appellant's lawsuit was dragging out. So for them, there was also some ongoing irreparable harm to them waiting for that construction plan to be finished. And they were afforded an opportunity in the jury trial, or in the bench trial below, to be able to raise those concerns to the judge. So with respect to the irreparable harm issues, I think the judge properly considered evidence of those factors and was able to balance that appropriately. And with respect to your question on res judicata, I don't know that any of them would be preclusive in a jury trial going forward because, again, they were solely related to that injunctive relief issue.
So it's your position then that the remaining damages claims in this case can be tried to a jury, and the jury is free to reach whatever conclusion it reaches, whether it's consistent or inconsistent with the injunction?
Absolutely, and I believe Judge Nesser was extremely clear about that in not one but multiple different orders, indicating that the right to a jury trial was going to be preserved. I think he explicitly said that in his August 14th order, if I'm not mistaken. In the order effectively granting injunctive relief on these, again, this preliminary threshold issue to the association on the construction plan being able to move forward, he likewise was adamant that this was only going to resolve those preliminary injunction issues. I also want to note, because I don't want to miss it in some of the other issues or assignments of error that have been identified by the appellants, they've suggested that there was no notice that these were the issues that were going to be considered in the hearing before Judge Nestor. Judge Nestor, frankly, could not have been more clear in his written orders. He issued an order in June of 2024 and a subsequent one in August that specifically laid out the fact that these issues related to the parties' competing requests for injunctive relief were the sole issues that would be considered at the hearing, that they weren't going to get any further afield into any of the factual or substantive causes of action that had been raised in the complaint.
So in your view, what is left to be tried?
Again, causes of action 1, 3, and 4 I believe it's 1, 3, and 4 from the plaintiff's initial complaint. I know Judge Nestor dismissed the second cause of action, but if I'm not mistaken, his reasoning on that was because a component of determining the threshold issue on equitable relief was determining whether or not the board had the power to move forward to formulate the reconstruction plan with experts and then move forward with it.
So you believe those claims are left to be tried before a jury?
Correct.
That's where we are.
Correct. That's correct, Judge Krause.
Okay.
And again, Judge Nestor could not have been more clear about that.
And then if they come to an opposite conclusion on certain factual issues, then the judge, then what?
Well, with respect to, I guess I want to understand your question, Judge Krause, with respect to factual issues on what specifically?
Well, I mean, the judge made certain findings of fact that potentially a jury might come to an opposite conclusion on these on these counts, right? So,
Are you referring to like irreparable harm potentially?
well, there were numerous findings of fact in the judge's order. So would you not agree with that, that he made findings of fact?
Forgive me, I'm just trying to determine which one you're referring to.
I am referring to every finding of fact that the judge made in his order. And the question is, you envision a jury trial, that there's still a remaining jury trial to be had.
That's
Right.
true, and I guess I could pick one out of my head at random. Particularly, the city of Cincinnati indicated that the building would not be safe in the absence of
Right, the code
comprehensive-
upgrades are necessary,
Correct.
right? Whether they are necessary
Right,
to
so
put
the-
a sprinkler system in.
Right, so the question of whether or not the city of Cincinnati had provided that determination and issued an alternative design that would require the sprinkler system that could be approved in lieu of the extremely and inordinately largely more expensive option of, demolishing everything and reconstructing large fire floors. Yeah, I believe that that would be something that the judge would have already decided, that I don't know how a jury could decide differently on that issue. It's what the city of Cincinnati provided as evidence in that case through its building inspector.
Okay.
And what about the conclusion? I mean, the trial court implicitly construed these documents. I mean, one of the claims is that the residents were entitled to vote on the plan. And the trial court implicitly rejected that in granting injunctive relief to the association and denying the residents, the plaintiff residents'
Correct.
claim for injunctive relief. That potential conclusion could undermine some of the remaining claims, right?
I don't think that it would undermine any of the remaining claims in the absence of the one that he did ultimately dismiss, that Judge Nestor ultimately did dismiss. For the remainder of the claims, I believe those would still be live issues. So
All right.
with respect to the question that Your Honor raised about that the residents were entitled to vote on the installation of the sprinkler system, that required just purely a legal determination of an evaluation of what the governing documents provided. So I don't know that that necessarily required any additional factual evidence to reach that conclusion. It was just a legal determination of what the governing documents provided.
All right, so your position is that the plaintiffs were never entitled to a jury on that claim anyways, on its merits?
It would be strictly a legal conclusion. I think Judge Krause brought that up in the initial back and forth colloquy with counsel for appellants. If it's a breach of contract claim, if it's an interpretation of a document claim, that's a purely legal issue that a trial court judge is inherently empowered to decide, as opposed to submitting it to a jury. Frankly, doing trials myself, it would be incredibly confusing to try to put a contract in front of a jury and ask them to interpret what it means or how it should be enforced.
What about the fact that they were not asked, that a plan was developed and that they were not asked to vote on it? Who determines that fact?
I guess I don't understand the question. I apologize, Judge Kinsley. The question of who has the power to formulate a reconstruction plan with the city of Cincinnati? I mean, I think it's pretty clear in the governing documents that it's the board members that have the ability to do that. And again,
But
Judge
who
Nestor.
assesses that fact?
It would
The
be a
trial
legal-
court?
Correct. It'd be a legal issue for the trial judge to determine. Correct. And frankly, I think both Ohio law and the governing documents are uniform on this, that the board has the ability to make these determinations. I realize counsel has indicated that this is an extraordinary usurpation of power, but it's fairly well set forth in the governing documents and Ohio law, particularly that under exigent circumstances, the association and the board have the ability to take action in order to protect public health and to go into units via the easement that's reserved for it in the declaration.
And just so I'm understanding, would you say that this sentence, the plan approved by the board is reasonable, appropriate, and consistent with the board's duty to remediate, repair, and replace the damage caused by the fires? Is that for a judge or a jury to decide?
I believe it's for a judge to decide,
So
Judge
you
Krause.
think, okay.
So you mentioned the easement, which I'm looking at a definition here. It's an interest in land owned by another person consisting of the right to use or control the land, et cetera, for a specific limited purpose, such as what we normally see with an easement is for utilities or for a driveway or that sort of thing. In this case, there was a extended period where the residents had to vacate their homes. Is that an easement?
So within the language of the governing documents, yes, it is, Judge Bach. So I've got some of the language right here in my hand. And it authorizes the Board of Directors of the association to, quote, enter a unit for bona fide purposes when conditions exist that involve an imminent risk of damage or harm to the common elements, another unit, or to the health or safety of occupants of that unit or another unit. And I think we can all see why that would be an essential provision to try to reserve for a condo association, particularly a high-rise apartment condo situation, because the units are all interconnected with each other, and a threat to some of them or a threat to the common elements, including in this particular case, the flue shafts that were forcing toxic soot throughout the building had the potential of releasing asbestos throughout the building. So I think we'd see the reason for that to be reserved in the governing documents that again acts as a contract between the association and all members who sign on to become members. I see that my time is up. If you have any additional questions, I would certainly welcome them, but I appreciate the opportunity to argue in front of you today.
Thank you.
Thank you, Judge.
I'd like to address just a few things that I heard opposing counsel address with the court. The first question was whether the trial court could make preliminary factual findings in order to render the legal conclusions, and the answer here is absolutely not. And I think the confusion here is that this was not a preliminary injunction hearing. This was not a TRO. The trial court set this for a permanent injunction trial.
So do you agree then that in the baby steps to a permanent injunction, the trial court can make factual findings?
The trial court can certainly, it's pretty common in the preliminary injunction context for a trial court to make some findings as part of issuing that injunction or not. But that's not what happened here. The preliminary injunction hearing was consolidated with the trial on the merits, and then the court severed it. The court severed the remedy of injunctive relief from everything else. And I think this question that the court had about imminence and what opposing counsel said about the city's testimony is a perfect example of why the trial court couldn't do what it did. The question of whether that very provision that he was referencing, that the association could enter if there's imminent harm, what actually happened at trial is Art Dahlberg from the city of Cincinnati said there was no imminent risk of harm.
You just made a really intriguing point. What claims were actually tried in this trial? You're pointing out that there was a specific remedy that was tried, but what claims were at issue?
I think that's a great question, Your Honor, and that's the question that appellants struggled with, because we moved to have the entire case consolidated and tried. And we got a number of different orders from the trial court indicating it was severing and going to try the injunctive relief claims only. We didn't have a claim for just injunctive relief. We had 7 causes of action, each of which sought damages and injunctive relief. And as the court knows, injunctive relief is not a standalone claim. So we're not sure what exactly the trial court tried here, and that's part of our issue with lack of notice. In addition to that, just prior to the trial, the trial court denied our motion to compel. We weren't even permitted to take depositions of board members or get emails. And the basis for that finding was he was just going to make determinations of law. No factual issues were going to be determined, but as the court has pointed out a number of times here, that's exactly what the trial court did. And we were denied the opportunity to do discovery and then to present testimony and facts on those issues at the trial.
So what are you asking for? What would you like to happen now, given the current state of the condos?
I think the only thing that the Court of Appeals can do is reverse and remand this entire case with instructions that it needs to be tried to a jury. The jury has to make the determinations of fact and the damage claims before any question of whether there should be injunctive relief can be had. It's certainly true that some of the injunctive relief may no longer be available, but some injunctive relief is, we think, and certainly the damage claims. The damage claims are still there, and we would like to address those damage claims. As to the preclusive effect, I do think the case law indicates that when a trial court makes findings of fact when it's not supposed to, it's not res judicata. The problem here is that the trial court dismissed count 2 in its entirety, and that's the primary part of this case, because that is our claim for breach of the governing documents and breach of fiduciary duties. And so by dismissing that claim, I don't think the Court of Appeals could simply say no res judicata effect, because by dismissing that claim, the trial court essentially decided the whole case.
And counsel, you're out of time.
Okay, thank you, Your Honor.
Thank you very much. Thank you both for your arguments this morning. We will take the matter under submission and issue a timely written decision. The court will stand in a brief recess for about 5 minutes. Thank you.
Thank you.